sacrifice in a world not of their make. Turn from your faith and expect it to go away. It'll be in your face, leave a bitter taste that returns again and again.
Gather up your strength, go out and tell your friends.
Any action, even a fraction, makes a difference in the end.
That life can be full,
The life can be fair.
there's plenty for all,
Enough for us to share.
how.
Together, 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 all as one. Together, together, it can be done. Oh, together,
Together, together, all as one.
together, together, it can be done. The future starts here and now, and it can be bright. The hopes of tomorrow are born this night. Together, 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 all as one. Together, together, it can be done. It can be done. Yeah. Together, 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 all as one. Yeah. Together, together, it can be done. It can.
Good evening and welcome back to the Human Rights Enigma. Tonight, children, divorce, custody, and human rights. Unfortunately, the sentiments expressed in our musical opening are not often reflected in the real world. For millions of children, the song is, "We are not together, we are alone, disenfranchised of our rights, unprotected, in need of warmth and reassurance." We are all aware of the breakdown of the traditional family structure in the United States and in other Western nations, but we show no appreciation of the terrible consequences that follow from this fact. Divorce statistics in the United States continue to rise steeply. Conservative estimates cite rates of 1 in 2 and even higher in urban centers. In Europe, the figures are comparable. Family courts in many states and nations have consistently granted almost universal sole custody to mothers, severely limiting and often excluding even the most involved of fathers from any semblance of active parenting, while seriously abrogating their parental rights under human rights law. In fact, the international rate of sole maternal custody stands at close to 92% of all conflictual cases. That means that currently, according to the Children's Rights Council, there are over 6.5 million children who have lost contact with their fathers in America, while in Britain, the figure is approximately 1.5 million. The American anthropologist Margaret Mead offered the following insight, and I quote, "We have permitted the courts to sever the relationship between a child and his or her biological father. This is something that no court should ever have an opportunity to do." Are we denying justice to men and children? What are the implications for us as a society if we continue along this present course? So let me introduce our very special guests for this evening. I'm very pleased to have across from me Dr. Puri Quisumbing, who we congratulate on her recent appointment as representative of the United Nations High Commissioner for Human Rights. She is chief of the Center's New York office, an experienced international lawyer with a PhD from Columbia in philosophy, with long experience in human rights issues, and she has a very special interest in children's issues. Also, a welcome to my friend and colleague, Joseph Sahid. Joe is a New York attorney, complex litigator, who has argued several important cases, and he has served as a staff member of the National Commission on the Causes and Prevention of Crime. He has authored Rights in Concord, Law and Order Reconsidered, and games politically violent people play. Apart from all of this, he is a member of the Children's Rights Council, a national charitable organization, and he is an advocate for reform of our family law justice system. With all of that, we can begin, I suppose. Now, the first question I have is, can we say that we're all in agreement, which we may not be, that the current circumstances confronting us, granting almost universal custody to women, really reflects the obverse of the kind of cruel and unjust circumstances which existed from Roman times up through the 19th century, where women had no rights in custodial matters, and men treated their wives and children as chattel and invariably got custody. Does anybody have a comment on that?
Stuart, I think we have to go back and say we don't have real responsible authoritative studies that this is the case. But I think from an anecdotal and experiential data, we know that indeed the traditional laws in almost all countries, both in developed countries as well as developing countries, the family law has always provided for a preference for maternal custody when the child is below a certain age, and usually it is below 7.
This was the tender
Yes.
years doctrine, which
Yes.
I think finally may be coming into disrepute.
But I think that there are many things now that have changed this approach. And I'd like to begin by saying that we should take a look at the minimum standards that define the rights of the child. These are contained in the convention, the United Nations Convention on the Rights of the Child.
Well, could I stop you there and ask you to explain to our audience at home exactly what the convention is and how it operates?
Well, the Convention on the Rights of the Child is both, I would say, a body, a codified body of values on the rights of the child. Codified because they didn't come from nowhere. It took 10 years for all governments as well as non-governmental organizations and interested parties to come forward and forge this what I would call universal standard of recognizing children's rights. And
But what are these rights?
Well, these rights are basically civil and political, economic, social, and cultural rights of children. The idea there, Stuart, is that for the first time, children are recognized as human beings with inherent rights. They don't have to grow up to the age of majority, whether it be 18 or 21, to have rights.
All right, does the convention, and I know we're going to discuss this at length, does this incorporate the notion that a child has, despite the status of the parents, their own relationship, that the child has a right, a human right, to a continuing relationship to both of its parents?
Oh, absolutely. That's basic to the whole notion. It's a basic principle, and it runs through the whole convention. It starts with Article 3.
I want to stop you there for a second because I see Joe is champing at the bit, and I know he's looked at the convention and he has a comment or two to make because the convention discusses what might be in the child's best interest. And Joe, you have strong views about that doctrine itself.
Well, the first thing, I think it's wonderful that the UN has adopted something.
No, we all say amen
lines.
to that.
Yes, and I don't mean to denigrate it at all. It'll be interesting to see how it gets interpreted and applied in the coming years.
What problem have you got with it?
On its face, it certainly raises some questions about what it can accomplish. Article 9 for example, is I guess the key provision for what we're talking about here. It says, parties shall ensure, state parties shall ensure that a child shall not be separated from his or her parents against their will, except when competent authorities, subject to judicial review, determine, in accordance with the applicable law and procedures, that such separation is necessary for the best interests of the child. Now that starts to send warning signals to me, because it hinges on the phrase best interest of the child. And the experience in the United States in recent years is that that phrase has been turned against fathers. It is not something that is really done for the best interests of the children. It's something that's done for the best interests of the custodial parent.
Let me just interject a question here. It's not one that I planned on asking, but I want to ask you both. If my figures are accurate, and I think they are in the main, that over 92% of all cases that come before the courts are decided as sole custody decisions in favor of mothers, if we were talking about any other group or classification of people, if we were talking about Black Americans, if we were talking about Hispanics, if we were talking about gays, would we be thinking in terms of some kind of discrimination in the judicial process?
Of course. To say it is to answer it affirmatively, and that's the problem. If we had a situation where 92 or 98% of the jobs that I gave out, I gave to whites, right, in a society where blacks made up 20% of the population, there would be, the courts would be climbing all over you, saying, wait a minute, something's wrong here. And in fact, the United States courts have done that in recent years. On the other hand, we give 92 or 98% of the custody awards to women, and nobody notices. It's not something that raises anybody's concern.
Well, let me ask Puri then. Is there room here for the basis for a complaint by, we'll say in this case, American men, and you might just as well say British men, they're in the same position as our Spanish men and many other groups. Is there a basis for a complaint? Are there any provisions in treaty law, international treaty law, and covenants to protect people against sexual discrimination? And would that apply in this area vis-a-vis the child?
Well, there are many international treaties that one could obviously invoke for equality, and anti-discrimination principles are all over the human rights treaties. But I'd like to concentrate on the rights of the child. We're looking at this, right, at least I'm looking at it from the child's right, rather than the right of the father, exactly, or the right of the mother. Right. And I think here one takes a look at the convention that says that the child should not be deprived of the parental love of both father and mother, and that there should be no discrimination. So I think on the basis of that, certainly the father, if indeed the father is discriminated against, can invoke this, not from the point of view of his right, but the right of the child to his
within
love,
the terms of the convention.
Within the terms of the convention. So I'd say that here one looks at the basic principle of the best interest of the child. And while Joe is looking at Article 9, I'd like to say probably the more basic one is even Article 3, which specifies that states parties in all actions, whether this be judicial, administrative, or even the actions of persons who are caregivers, legal guardians or simply caregivers, both public as well as private institutions, when they make a decision or an action, the best interests of the child should be of primary consideration. Plus, and in subsequent articles, it says, plus that it should not just be determined, the best interest of the child should not just be determined by authorities. Here,
right,
very importantly,
right,
I think this is very important for us to input here, is that the convention now says that the child participation in determining his best interest is most important. Now, of course, you can argue about, does the child know? And
yes, and it raises other issues, parental alienation being one of them.
There's another guideline in the convention that says this is according to the evolving capacity of the child.
Right.
And that,
The principle is important.
The
I agree with
principle
you.
is very important because I think no matter look, we're taking a look at a global
Exactly.
standard, and maybe the interpretation will vary somewhat from jurisdiction to jurisdiction, but the basic principle should be there. And therefore, from the point of view of the Convention on the Rights of the Child, I'd say the child should not be deprived of the right to the love of the father and the love of the mother. And here it says parents. It doesn't say anything about whether parents should be legitimately connected.
Well, that's very interesting because it now brings me to a case I'd like to raise.
Before we get there, may I just take one more minute on this subject, because I'm going back to the words of this thing to see if we can. We're using concepts, best interest of the child. What does that really mean?
We need to work out an objective criteria. Maybe we need a Bill of Rights for children.
Well, let's talk about something very particular that they do talk about in here. It says, we're talking now about when it's okay to separate a child from its parents. And it says, where the parents are living separately and a decision must be made as to the child's place of residence. Now, just below that, it says, states parties shall respect the rights of the child who is separated for one or both parents to maintain personal relations and direct contact with both parents on a regular basis, except if it is contrary to the child's best interest. Now, we have these very important caveats that are built in here. Let's now talk about a very specific situation.
Right.
The children children who have a very good relationship with both parents are living separately because the parents have divorced. And one parent who has the custody of the children says, I wish to move. I'm living in New York and I want to go to California. And the other parent, let's call him the father, says, wait a minute, I'm still here in New York. That means I won't get to see the children. Well, given the language I just read, what happens?
Well, plus you've got a recent case in New York State in the appellate division, which is a very landmark case.
And what we talk about is we say, of course, in New York now, and as I read this UN provision, it says, of course, the custodial parent can move because it's in the best interest of the child. I didn't hear the child asking to move.
All right, well, let me interrupt you and ask Puri then.
Move.
Do you think, I think the points that Joe raises are incredibly valid and the caveats are dangerous. Do you think we need to move, because they couldn't have envisioned that. They wanted to set down a principle, a set of principles. And I agree with you. I think the document is laudable and it's an important document, the convention. But do we need at this point, Puri, perhaps to move beyond and correct some of the errors of language or the loose terminology, or to objectify these criteria which are described as loosely as best interest? Do we have to move beyond this?
Well, every international treaty is always considered a political document. You will always have compromises in language, and particularly true with international human rights instruments. So what needs to be done, I agree with you, is to elaborate these treaties, and there are efforts now to elaborate, not necessarily to correct, but probably to clarify. But I'd like to address that caveat that you say can be very dangerous. Let's take a look. You're looking at a situation which is ideal, where there are loving parents, where there are
No, I don't think we are. I think we're looking at conflictual situations.
No, I'm see, you're looking from parent side. I'm looking from child side, which I think is very interesting as we go along.
Well, I think both sides need to be addressed.
Right. So I'm saying that this document is looking at the child side. Now, when we talk about dysfunctional families, where not only is it dysfunctional from the point of view of the relationship between parents, but dysfunctional from the point of view of the child vis-a-vis either one of the parents.
Exactly.
You can have abusive parents, and unfortunately, and I think this is where we need to put some studies in.
Well, exactly. But those cases are the aberrational cases.
But that is why when there was a discussion on this, the question was where because it doesn't say father. says
Yes,
parents.
it's neutral.
And therefore, if let's say in the case of the father, if the father takes away the child because the mother has turned into a person who is not the kind of parent that you want, then you obviously want to distance the child from that
Fine.
parent. So
Well,
I think
okay, all right, yes, I think that's an interesting. Let me just stop you there because.
Well,
what if we had a presumption?
We know how to write words that say if there is physical abuse of a child, then we will apply different rules.
A different standard, exactly.
That's not what we do.
No, what I was going to suggest is
we use that as the boogeyman in order to create a wide exception which swallows up the rule.
No, I agree with Joe. I think perhaps if we looked at this from the point of view of the child, and I'll do that too for the moment. I'll wear my child's hat, and the child is one of a triad. A family is a triad. There's a mother, a father, and a child. Regardless of the state of the relationship between the parents, let's assume it's conflictual. Let's say that this is not an aberrational case. There isn't any tremendous dysfunctionality. It's just a couple, and they're in conflict. And the way the law is written and enacted in most countries, it's adversarial in court processes, and women are winning custody and men are just losing their parental rights. The child is thereby losing a parent. So let's take the child's position. What if we wrote into a document like this, that there's a presumption in law, a presumption, that the child is entitled to a relationship with both parents and that there shall be a joint custody?
But it's in the convention.
Is it? I
Yes,
didn't see
Article 9 had just been read to us.
Does that read as a presumption of joint?
Yes, all throughout. It's all throughout. There is a presumption that a family is the most basic unit
of society.
And no, not only that. It's the most basic family environment that is good for the child and that is supportive and promotive of child rights. That is the philosophy of this. And from the very beginning, from the preamble, it says that the family has to, in fact, be supported by the state. And what is interesting, in fact, with this convention is that the responsibility of the state party is to promote the unity of the family. And if the family is unable to give or provide for the child, then the state has to help that family. And going beyond that, it even says, particularly in developing countries, that that this should be done within the framework of international cooperation and with non-governmental organizations. So I think that we have to see the whole context, not just individual articles, but very basic is the philosophy of the convention that the rights of the child will best be promoted and protected within the family unit.
Okay, well, let me just switch over here now, because I did want to raise this case, which I think might pose a dilemma both for us in America and also for the United Nations, looking at the global context and the human rights side of the issue. There was a case, and the case was called Michael H. Versus Gerald D., and it went to the Supreme Court in 1989, in which the Supreme Court held constitutional a local statute, depriving a biological and a psychological father from his parenting rights over his child. The law in question, which is called California Evidence Code 621, to be precise, created the legal fiction that the husband, you have to listen to this carefully, it's very strange, that the husband of a married woman, although not the natural biological or psychological father, is conclusively presumed to be the father. So that in this case, Michael, the natural father, was therefore prevented from obtaining his rights over his own child. He had no visitation, no relationship to his child. The question I wish to pose first to Joe is this sane? And is this a violation of his liberty interests in terms of our Constitution? And then I want to ask Puri whether this is possibly a violation of human rights law.
The first answer, I think, is that this is a very special case. The court refers to the father here as the adulterous natural father 6 times. And it was clear that Justice Scalia, who wrote this opinion, did not have much sympathy for adulterous natural fathers. And that's really what this case is about. It engendered a whole bunch of different opinions by all the different judges, everybody. having trouble with this case. So I don't think that this case tells us much about what will happen in the more traditional situation of a family that divorces.
But what kind of signals is it sending?
Well, it's saying that adulterous natural fathers in the United States are not going to get too much sympathy from Justice Scalia, and at that time, 4 other judges of the Supreme Court. I think one of the most disturbing part of the whole opinion was one sentence in here that Justice Stevens wrote in his opinion, and I'll just read it so I get it right
well,
here.
we needn't worry about because I think we've captured the essence of it. Let me just go on because we're running short on time.
Right.
Puri, would this case be a kind of prototypical case for a human rights violation action?
Well, you know, I don't really want to talk about American law and American jurisdiction. All I can say is that I think it shows us that the United States should adhere to the Convention on the Rights of the Child at some point. It's one of 6 countries that had not become a state party to the Convention on the Rights of the Child.
And we're going to be discussing this later.
My point only is that the case would seem to contravene the basic principle of the convention contained in the Convention on the Rights of the Child. And even if the United States has not become a state party.
Well, yeah, exactly. I mean, the United States has signed the convention, but it hasn't ratified it. So how would this man bring an action? How would he seek a redress or a remedy?
Well, I think that first you have, anyway, I mean, the general principle is that before you can take anything to the international court or international institutions of justice, you have to exhaust
local remedies,
domestic remedies. So
well, he's done that. I would think he's gone to the Supreme Court. You can't get much higher than that.
Okay, and there's
to go to God.
The Inter-American justice system and human rights, and he could probably try that. And number 3, I think that maybe the United States should, in fact, ratify the Covenant on Civil and Political Rights and the protocol that would allow individuals of the United States to go to the international system.
Well, I think it's a wonderful point to stop because we've run out of time. And to end this evening's program, I wish to refer again to that leading feminist, Margaret Mead, who once explained, and I quote, "We have given the kind of preference to the mother-child tie that belonged about 500,000 years ago, and as a result, we are eroding parental responsibility and paternal responsibility at an appalling rate in this country." And she also warned, quote, "The courts, by refusing to recognize the rights of fathers and children, are practicing reverse sexism that is insulting to real women." And she advised, if we could keep the tie between parents in the aftermath of divorce, we would protect children far better than we do now. So with that in mind, from Stuart Rhine and the Human Rights Enigma, good night, Godspeed, and be ever watchful of your rights.